In another lesson, we defined reproductive rights. We also dealt with abortion. In this class, we will study an influential judicial case on abortion, Roe versus Wade, decided in 1973 by the Supreme Court of the United States. Following in the common law tradition, ever since the United States had acquired nationhood, abortion was not criminalized if performed before quickening or the first recognizable movement of the fetus in utero, which takes place usually from the 16th to the 18th week of pregnancy. Yet, between the mid-19th and mid-20th century, abortion became criminalized, except to save the mother's life, and contraception strongly restricted throughout the country. During the 1950s and 1960s, a social movement began to demand the decriminalization of abortion. By 1973, reportedly 64% of Americans thought abortion should be decided by the woman and her physician only. Abortion had been a criminal offense in the state of Texas since 1854, except when performed to save the mother's life. In 1970, a Dallas resident, acting under the pseudonym of Jane Roe, instituted a federal action against the district attorney, Henry Wade. Ms. Roe sought a declaratory judgment that the Texas criminal abortion law were unconstitutional, as well as an injunction preventing Wade from enforcing those laws. Roe filed her action on behalf of herself and of all other women in similar circumstances. Although the district court declared the Texas statute void due to its vagueness, it denied the requested injunction in 1970. That same year, Ms. Roe appealed the decision before the Supreme Court, claiming a violation of a constitutional right to personal privacy. The court delivered its ruling on the 22nd of January 1973 by a 7-2 majority. The court acknowledged that there is no right of privacy expressly declared in the Constitution. However, starting in 1891, the same court had recognized such a right to personal privacy, stemming from a number of constitutional amendments, including the first on freedom of religion and of speech, the fourth on security of the person, home, and correspondence, the fifth on the protection of private property, the ninth on other rights retained by the people, and the 14th Amendment on due process of law and equal protection of the laws. Hence, the court concluded literally, the right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The court also said that maternity or additional offspring may force upon the woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by child care. There is also the distress for all concerned associated with the unwanted child, and there is the problem of bringing a child into a family already unable psychologically or otherwise to care for it. Now, the court also pointed out that the right of privacy is not absolute. Although the unborn does not qualify as a person under the U.S. Constitution, the court was convinced that the state may have a legitimate interest in regulating abortion. The core of the court's reasoning in this point lies in the 14th Amendment to the Constitution, guarantee of substantive due process of law. That is, the need for every legislation to be fair and reasonable in content and to further a legitimate governmental objective. In the case of abortion, the court held that the woman's privacy must be measured accordingly with the interest of protecting her own health and also of safeguarding potential human life. Thus, the court constructed its well-known three-tier model in an attempt to balance all rights and interests involved. It ruled that during the first trimester of pregnancy, the decision to have an abortion is left to the woman's physician in consultation with her. During the second trimester, as the risk for her health increases, the state has a legitimate interest in regulating abortion procedures, including the qualifications and facilities required, so as to safeguard the life and health of the mother. Finally, after the compelling landmark of viability of the fetus, which happens between the 24th and 28th week of pregnancy, the court ruled that the state has a legitimate interest in protecting potential life, and it may lawfully prohibit abortion except when needed to preserve the mother's life or health. As the Texas Penal Code banned abortion, making no distinction between early and advanced stages of pregnancy, the court declared it unconstitutional. In his dissenting opinion, Justice White denounced the majority's ruling as an improvident and extravagant exercise of the power of judicial review regarding an issue that should be left with the people and to the political processes. The Roe decision immediately provoked intense criticisms known as the Roe rage. For instance, Yale professor John Hart Ely argued that the court ruled outside the boundaries of constitutional law, since the right of privacy refers mainly to private information, thus returning to the court's darkest day of abusive judicial review earlier in the century. A similar opinion was issued by Justice Scalia in his dissent on the Casey case, remarking that the Constitution says absolutely nothing about abortion and that it should be discussed and resolved by citizens in a democracy, not by judicial fiat. Conversely, Professor Ronald Dworkin contested that pregnancy entails bodily changes that are closely related to a woman's privacy. Although the U.S. Constitution does not mention abortion, Dworkin believes that liberty and equality therein are sufficiently abstract so as to encompass the right to procreative autonomy. He also thought that the state has a legitimate interest in taking seriously life and death decisions. As for its effects, Roe's three-tier model was welcomed in Italy, where a law passed in 1978 made abortion completely legal for the first trimester, and from the second trimester only in order to safeguard the mother's health or due to serious malformations of the fetus. Other countries also legalized abortion under certain circumstances during the 70s, including France, West Germany, New Zealand, and South Africa. The European Court of Human Rights has also ruled in favor of abortion in certain cases pursuant to the right of privacy. In Latin America, the Colombian Constitutional Court declared unconstitutional an absolute ban on abortion, authorizing it to safeguard their mother's health due to malformations of the fetus or to rape, incest, or forced pregnancy. For an overview of abortion around the world, please watch our previous lesson. In 1992, Roe was challenged before the U.S. Supreme Court in the case Planned Parenthood of Southeastern Pennsylvania versus Casey. Yet, In Casey, the Supreme Court upheld the Roe decision regarding the need to balancing the right of privacy of pregnant women with legitimate state interest, albeit discarding the three-tier model. Instead, the court proposed that prior to the landmark of viability of the fetus, which could take place, according to modern medicine, as early as in the 22nd week of pregnancy, the state could legally regulate abortion, but without imposing an undue burden on the woman. The court deemed unreasonable the burden of previous consultation to the woman's husband, but not that of a 24 hours wait. Beyond the threshold of viability, abortion could be prohibited, except to safeguarding the mother's health. The court also pointed out that since Roe, people had organized their life choices around the existence of a constitutionally protected right to abortion. So these legal expectations had to be respected too. Thank you for watching this lesson. Please visit our website mookchile.com and we cordially invite you to watch our next class.